Hello everybody, welcome to Chapter 34 review. We are now going to cover liabilities to third parties and how agency relationships are terminated. Let's discuss the following. Do the principal and the agent have contractual liability, and how so? In a contract dispute, the third party's knowledge or lack thereof determines the classification of the principal. Principals may be either disclosed, partially disclosed, or undisclosed. With regard to unauthorized acts, an agent is not liable if he or she acts within his or her authority for a disclosed or partially disclosed principal. If the agent acts within his or her authority for an undisclosed principal, the agent is liable. With regard to unauthorized acts, the principal is not bound to an agreement made by an agent who acts outside of the scope of his or her authority. How does tort liability apply to an agency relationship? When an agent commits a tort that injures a third party during an authorized or unauthorized act, the agent is personally liable. The principal may or may not be liable depending upon whether the principal controls the agent's behavior. When a principal engages in tortious conduct, the principal is directly responsible. If the principal directs an agent to commit a tort, he or she is authorizing the unlawful behavior. The principal must provide proper instructions and tools. Under the doctrine of the respondeat superior, an employer is responsible for the actions of employees. When the employee is furthering the employer's business, this doctrine will apply. Likewise, if the employee is acting within the scope of their employment and they have not deviated from the employer's business in a substantial way, this doctrine will also apply. A person who hires an independent contractor is not liable for the contractor's actions unless the independent contractor engages in extremely hazardous activities for the principal. Principals are not liable for agents' crimes unless they authorize them. How can an agency relationship be terminated? Agency relationships may be terminated by the acts of the parties. They may also be terminated due to the lapse of time, the fulfillment of the purpose of the job, mutual agreement by the parties, revocation of that authority, or renunciation by the agent. Agency relationships may also be terminated by operation of law. This could be automatic termination, death, insanity, bankruptcy, changed circumstances, impossibility, or war. Within the next slide, we will discuss how a court determines the extent of the power of attorney in the case called In Re Estate of Kurlmeyer, which is outlined in your online text. Let's discuss the case of In Re Kurlmeyer. The facts of the case are as follows. After Louis Kurlmeyer had passed away, his wife transferred Louis' home into a trust. Louis' son brought a suit against the wife of Kurlmeyer, arguing that the transfer was in violation of an express provision in the power of attorney prohibiting the wife from making gifts to herself, as well as the fact that such a transfer was never explicitly granted in the document. The issue before the court was as follows. Does the defendant have the power, under a durable power of attorney, to transfer her deceased husband's house into a trust? The procedural history of this case is as follows. The trial court ruled in favor of the defendant, Kurlmeyer's wife, and then the son appealed. The holding was as follows. This was affirmed in the higher court in favor of the defendant, Kurlmeyer's wife. The reasoning was as follows. When interpreting a document such as the power of attorney, it is of primary importance to determine the intention of the parties, as looking at the text of the power of attorney alone does not always reveal what the person who wrote the power of attorney desired. The rule of strict construction that the son is using to make his argument is far too limiting in this case and does not provide a full understanding of what was intended through a power of attorney. The primary intention, as expressed in the form of testimony and written notes of Kurlmeyer, was to provide for his surviving wife and the decedent intended the power of attorney to allow his wife to transfer the Clearwater property into the trust that she had created, such that the wife could be more financially secure. Let's discuss the Iglesia case. The facts of the case are as follows. Pacheco, the pastor of a church, had sexually assaulted LM. LM then sued Pacheco and the church. In this case, the court considered the scope of the employment relationship with Pacheco. The issue before the court is as follows. Is the church liable for a pastor's criminal act under the doctrine of respondeat superior? The procedural history of this case was as follows. The jury found that the church was liable for the pastor's criminal act, and the church then appealed. The higher court then held that no, this wasn't the case, and the church would not be liable for the pastor's conduct. The reasoning is as follows. Under the doctrine of respondeat superior, an employer cannot be held liable for the tortious or criminal acts of an employee unless the acts were committed during the course of the employment and to further the purpose or interest of the employer. The sexual assault did not occur on the church's property. The criminal act against LM did not constitute the kind of conduct the pastor was employed to perform. Pacheco was satisfying his personal interests. There was no counseling that occurred on the day of the crime. The sexual assault was independent and a self-serving act of Pacheco. The church cannot be held vicariously liable for Pacheco's act. Let's discuss the Jerry Mays versus the Alliance Life Insurance Company case. The facts are as follows. Within this case, it's going to highlight the importance of understanding how an agency relationship is terminated. In 2005, Jerry Mays purchased life insurance policies for himself and his wife from Alliance Life Insurance through an agent named Josias Fabian. In 2007, Alliance terminated Fabian's agency because Fabian had failed to renew his license to sell insurance. By the terms of his termination of agency, Fabian could no longer open or accept money for new accounts, but was allowed to continue accepting checks on behalf of Alliance to be deposited into his existing accounts. However, Mays was not aware of these changes in Fabian's agency, and Alliance never informed Mays of these changes. In 2008, Mays met with Fabian in order to set up a trust account. Mays gave Fabian a check for $121,000 payable to the Alliance trust account. Instead of delivering these checks to Alliance, Fabian stole the check and deposited the money into a personal account. In 2011, the FBI charged Fabian with wire fraud, and it was then that Mays learned from an FBI agent that Fabian had stolen Mays' checks. Mays sued Alliance, claiming that the company was negligent for failing to exercise due care. The issue before the court was as follows. Was Alliance guilty of negligence for failing to inform Mays of its relationship with Fabian? The holding of the court was as follows. Alliance was found guilty of negligence and was liable for the $121,000. The reasoning was as follows. The court ruled that due to the contractual relationship between Alliance and Mays, Alliance owed a duty of service to Mays' account with due care. The nature of the relationship with Alliance and Fabian meant that the harm inflicted by Fabian was foreseeable. At minimum, Alliance was negligent in failing to tell Mays that Fabian's was unauthorized to sell Mays a trust account.